All right, Madam Chair, members of the committee, can you hear me okay, everyone in the room? My name is Candace Brose, and I currently serve as Commissioner of the Department of Human Services and Director of the Division of Family and Children's Services. Thank you for the opportunity to join you today and for the work that this committee will pursue to improve the lives of families and children across our state, and for the legislation you'll consider in today's meeting, which is a package of very carefully crafted bills to improve the juvenile code based on months of dedicated work by well-respected juvenile court judges, current and former special assistant attorneys general who prosecute child abuse and neglect on behalf of the state, and veteran DFAC staff. And importantly, with the full weight of the governor's and lieutenant governor's leadership behind these efforts, we have a real opportunity to make lasting positive change for Georgia's children. We commend the lieutenant governor for creating this committee, but even more so for putting a stake in the ground right out of the gate to prioritize adoption and foster care reform. It shows how deeply he cares and how deeply you care about the most vulnerable children in our state, committing to improving the child welfare system as a whole so they have a better shot at being safely reunified with their parents, being adopted by a loving family, or aging out of state custody with the right tools to succeed in life after foster care. Without question, the Lieutenant Governor has carefully and thoughtfully selected the right people to serve on this body under the leadership of Chairwoman Kay Kirkpatrick. When you consider the rarity that for all of these proposals, we have the backing of the governor, lieutenant governor, 4 Senate chairmen as lead sponsors, and incredibly strong co-sponsors, it underlines that there are just some issues everyone can get behind, and the time is now for Georgia's foster kids. Going in the order of today's agenda, unless there's been some last-minute changes, Senate Bill 134, sponsored by Chairman Bill Calzert, tailors 2 evidentiary rules specifically to juvenile court proceedings. Section 1 corrects an oversight from the legislative rewrite of the Juvenile Code to add termination of parental rights proceedings to the types of actions in which a child is competent to testify without the administration of a formal oath. And Section 2 authorizes the use of medical reports in narrative form on an accelerated timeline in dependency proceedings and termination of parental rights proceedings. Thank you, Chairman Calzert, whom I consider an evidentiary expert given his legislative track record and professional expertise, for agreeing to sponsor these important changes. Next, Senate Bill 131, sponsored by Chairman Blake Tillery, aligns statutory requirements for notice and service of process and aligns provisions as to proper parties for permanent guardianships with termination of parental rights proceedings. We're deeply thankful to Appropriations Chairman Tillery, who's provided invaluable advice to me on my toughest days at DFACS. And this measure will eliminate unnecessary red tape and confusion standing in the way of a child achieving permanency with their loved ones. Senate Bill 135, sponsored by Chairwoman Kay Kirkpatrick, primarily addresses what I imagine is a little-known fact, that a child's biological father may not be the child's legal father despite having an existing child support order and prior genetic testing. In addition to terminology cleanup, this bill will allow for that prior genetic testing to be later used in legitimation. Madam Chair, thank you for agreeing to sponsor this measure, which will benefit countless dedicated fathers across our state. Lastly, Senate Bill 133, sponsored by Chairman Brian Strickland, establishes a more uniform process for DFACs to assume custody of children following the order of a juvenile court judge in a delinquency disposition or a child in need of services hearing. This outcome is often referred to as custody from the bench by practitioners and judges. Senate Bill 133 ensures that there's an opportunity for DFACs and the parties to the delinquency or CHINS case to make efforts to avoid a child coming into the foster care system unnecessarily. In addition, this bill provides a procedural structure for the court after a child is placed in DFACS custody, ensuring more effective early interventions and services, protecting due process rights and constitutional liberty interests, and improving information sharing between state agencies to secure the most appropriate placement for a child. Although he could not be here today unless he's arrived recently, I want to thank Chairman Strickland for spearheading this legislation, which will have a direct and immediate impact on keeping children newly entering our custody from being temporarily placed in a hotel or office. And I appreciate Chairman Cowsert for presenting this bill in his absence. And now I'll ask for the committee's forgiveness. I am soon to head over to Dobbins for the Insurance Commissioner General John King's military retirement ceremony at 2 p.m. But I do have several members of my staff here, including my Deputy Chief of Staff, Matthew Kroll, our agency's General Counsel, Regina Quick, Dana Carroll, who's a former SAG, now is one of our in-house attorneys for child welfare, and Dina Krim, who's a current SAG on behalf of the state prosecuting child abuse and neglect. And of course, I humbly request your favorable consideration of all of these measures.
Thank you, Commissioner, for squeezing us in before you go
Sure.
to General King's retirement. And we certainly all would like to be there, too. So thanks for representing.
Thank you.
With that, we're first going to take up Senate Bill 134. Senator Cowsert, would you come up? He's
Just
got
in
the law
case.
book.
Got the book. Good prop anyway.
Oh, I forgot to mention to the committee members, in the back of your packet, you have a handout that has all the definitions that we're talking about, and you might want to hang on to that because you may want to refer back to them for other bills. Go right ahead.
Thank you, Madam Chairman. So I'm going to end up presenting three different bills today. The first one is the one that is really my bill that I am the lead sponsor on. The other two chairmen are tied up either out of town or in budget process, and so I'll attempt to present all three. Senate Bill 134 that really does two things to expedite the proceedings in some of these procedures that we deal with on dependency of a child, these dependency adjudications where we're determining whether a child needs to go into foster care. There's, I guess it was just an inadvertent situation where it was not included, but we have a couple of different provisions in the law where child witnesses are allowed to testify without being sworn under oath. Part of that's because of their age and their competency, their understanding of what it means to be under oath, et cetera. And so we allow essentially unsworn testimony from them in those type of cases. For example, where a child is a victim of sexual abuse or a criminal victim, they're allowed to present their testimony without being sworn under oath. And this just adds that in a proceeding where they're to be adjudicated as a dependent child, that they may give testimony without being sworn under oath. So that's really just to clean up from something that was omitted in the past. The other thing it does is in these dependency adjudications and parental rights termination hearings is to expedite the use of medical narratives from psychiatrists, psychologists, or physicians. This is used in the Civil Practice Act where people are allowed to present testimony from physicians without the physician testifying live. So it's an exception to the general hearsay rule where a witness has to be present to be cross-examined. In the General Civil Practice Act, car wreck cases, medical malpractice, whatever, you have to present such an affidavit, so to speak, but a written narrative is what we call it, 60 days prior to it being used. And that gives the opposing party time to go depose that witness or find rebuttal testimony, et cetera, to be prepared for their hearing. Because the timelines are so much more compressed in these dependency hearings and parental rights type hearings, we're trying to get an adjudication quicker than 60 days. In fact, the law specifies that we should in those other type of cases, and that's what we're trying to do here is to sort of get the law in sync with the time pressures that we have in these very important situations where we're dealing about with the termination of parental rights in particular. For example, a hearing in a case for termination of parental rights by statute is to be set 30 days after the petition is filed. So naturally, you wouldn't have this 60-day time period that is used in other cases. You wouldn't have time to give the notice. So this shrinks the time for that under these circumstances to 15 days. so that the opposing party can get notice, have a right to object, or respond to that before the hearing. But it also expedites the evidence in the cases because it is so difficult to get doctors to appear in court live due to their schedules. Some of them are not in the exact location, et cetera. And naturally, this is important where these termination of parental rights or the dependency proceedings, either one, are being based on the physical health or condition of the child, where you need medical expert testimony. So those are really the two changes that we're making there. It is a careful attempt to protect the rights of both the child and the state's interest in order to get expert testimony where needed in these shortened things. When you're dealing with a child protective hearing, you've got to have adjudication within 15 days after your preliminary protective hearing. So we shrink the time on those type of notices to a 7-day notice here in this provision. So all parties still get notification. They don't get blindsided when they get to a hearing, but it just compresses the timelines. And so with that, I'm happy to answer any questions that there may be.
Thank you, Senator. Questions from the committee? You must have done I started to say you must have done a really good job because there weren't any questions, but I'll have to take that back. Let's see, Senator Jackson, are you Mike 4? Okay.
Thank you,
I
Madam
might have
Chairman.
said 7 days. I meant 5 days on those dependency adjudications. They're so fast.
Thank you, Madam Chairman. Mr. Chair, I just have a question, and this is just a new field for me to understand, and so pardon some of my ignorance here. I feel like these medical reports that we're referring to assume that they're medical reports about the child, at least that's how it was presented to us. But could these medical reports pertain to the adult or the parent for whom the rights are being terminated, from whom the rights are being terminated?
It doesn't prohibit it from being used, those type as well. But yeah, you are right. Typically, it's where a child has been harmed, there's been physical injury to the child or sexual abuse that is revealed by a physician's examination or psychiatrist or psychologist.
But this could be this could be disputing parents in which one parent alleges that one of the parents is mentally unfit, and they provide a doctor's note to that effect.
Yes.
That parent who's being accused of being mentally fit under this would only have 15 days to dispute that. Is that how this reads?
Right.
Okay.
They actually you give the notice 15 days, and then they have to reply within 7 days prior to the hearing for any objections that they might have to the document. You said something about them replying. Their court date would be 15 days later. They could have their own physician come testify for them or a counter physician, but if they were going to object to this narrative report for any reason, they'd need to do that within 7 days.
Thank you, Madam
Receiving
Chairwoman.
that narrative report.
Senator, I just have a question as it relates to the notice. Could you explain how the notice would be, given, would it be through USPS mail? How would the notice get out? In these type of cases?
It doesn't specify in this. Ordinarily, where parties are represented by counsel, it's served on their counsel.
Right, but I'm just wondering if the two parents don't agree and the court doesn't have a good address or they provided something, just because the timeline is so short. One of the things that we've always tried to figure out is how to perfect service, and I'm just concerned about the parent actually receiving the notice with such a limited window, just to make sure that they did, in fact, get this notice, so that no one can say, oh, we didn't know, we didn't get it. Is there any way to, talk through how that notice would go out?
Yeah, and interestingly, you're about to hear that in one of these other bills about notice, and so it more than likely applies to all circumstances in this type of notice as well.
Gotcha.
One of the bills deals with notice of the proceeding against you, et cetera, that you have to be advised of it. And there's a series of ways, either from personally delivery, first-class mail, or even publication in a legal organ
Gotcha.
twice.
Okay.
I presume those would probably be effective for service of this type of narrative report as well. I'm winging it a little bit because that's not specifically addressed in this.
But it will be in the additional bills to come today. Okay.
So.
Thank you, Senator.
Any other questions from the committee? I don't think we have anybody signed up to testify. What's the will of the committee?
Make a motion to pass.
Okay, motion do pass.
I'll second.
And second by Dr. Payne, Senator Payne, Dr. Payne. Payne. Okay. Yeah. Any further discussion? Okay. All in favor, raise your hand, please. Okay. Thank you very much. The motion passes. Next, we're going to move to Senate Bill 131, and I'm going to assume. Whoops. I'm going to assume, Senator Cowser, that you're you're it for this one also?
I'm it.
Thank
Senator
you.
Tillery is the chief sponsor of this bill. I'm a co-signatory on that legislation. It's also part of this package, and it's to sort of true up or square up the notice provisions, how you're given notice of statutorily required notice. And we use the term service of process in the legal world, and process is ordinarily like a copy of the complaint or the petition that's being filed against you, and everybody has due process rights to be put on notice of some action against them before the law can impose these type of sanctions or this type of relief here. And we're dealing here with permanent guardianship hearings in this case. I think it was, again, a little bit of an oversight in the code on exactly how notice was going to be given in these circumstances. So this is where there's a permanent guardianship and also or termination of parental rights, those type of proceedings, what kind of notice would be given to you. So naturally, our preference is to give personal notice, where you are given a copy of the document, the petition or whatever against you, and where possible people attempt to do that. That's not always so easy, because unfortunately in some of these cases the parent or other interested person is gone. You know, they're not there. They have abandoned the child, or they're in prison, or they're, left the state or whatever, and or in some unfortunate circumstances their identity is unknown. So we're faced with some situations here where it's a little more difficult, but generally speaking, we are trying to serve the parents, and by service, it's just provide notice. That's just our kind of legal term, is service process, but you can kind of translate that into provide notice of the proceeding that's about to take place. So if you know where the person is, you should serve them in person. If you can't locate them, but you have a known last address, you can mail it to that last known address. If you do not know where the person is, or even a last known address, you may petition the court to give you an order to allow you to serve them by publication. Now, every county has a legal organ, we call it, where all those little fine print ads are printed in the back. Notices of foreclosure, notices of establishment of a will, so anybody has a claim against the state can make it, foreclosure sales, et cetera. Those are official legal notices, so people know, or should know, where to look for the possibility of any kind of action that would have legal significance to them. And so that's another way you can do service where you cannot find the person you're trying to serve, and the court gives you an order for that. Then you have to publish it twice in this legal publication after you've tried and failed to personally serve somebody or serve them by another method. So it gives us a sort of a series of ways to give somebody notice of these permanent guardianship hearings. Now we also discuss in the bill who needs to be served in these matters. And so we would naturally serve the mother of the child, assuming her parental rights have not been terminated already or voluntarily surrendered. The legal father of the child, if his rights have not been terminated or voluntarily surrendered. In some cases, there is no legal father, but you know the biological father, then you would serve that who is the natural father of the child. A legal custodian, in many of these cases, they already have a custodian, maybe even on a temporary basis so that they will know. And the attorney or guardian ad litem for the child need to be notified of the event. Now, if the child is 14 years or maybe it's over 14 years or older, I think so it reads, they should also receive notice of these proceedings. So with it, this is what we're doing, is just trying to clear up these methods of providing notice to people of these proceedings. So that's what this bill's trying to do, and I think it does it in a clean way that makes it consistent with the other type of notice provisions.
Okay, Senator, you have a couple questions. Senator Brass, is that you, Mike?
Well, thank you, Madam Chair, and thank you, Chairman Calzert, for presenting this bill for Chairman Tillery. So I may need to ask him this question, but you may know it. So I believe I heard you say that you believe that in person is the best way to serve, and I'm in agreement with that. My question is, I believe the department pays about $35 for, for either sheriff's department or a PI to go out and serve these people. If they go out and serve, can't find them in 14 days, and then they end up mailing it, do they still get paid? Would they still get paid that $35? Maybe that's a question for the department, but
I don't know the answer to that. I tend to presume that it would be, because you're
they still
paying them
turn
for
in
the
mileage
efforts
and
of trying to
right.
find it.
So they still would get. I'm getting a nod from the department over here.
That's
So
good then. I
okay.
certainly defer to the department, but that's logical.
okay, and then I guess so. If they're still getting paid, I did have a fear that if they were not going to get paid, then it was essentially going to encourage folks to just wait the 14 days, not even attempt to find them and then mail it. But as long as they're getting paid, I feel like we're not encouraging our SAGs not to even attempt to find them. So
I think you're right.
thank you.
Senator Jackson?
Thank you, Madam Chairwoman. Mr. Chairman, in the portions that were struck, it delineated who had to receive notice, and it explicitly stated that grandparents had to receive notice. I feel like a lot of the cases that come to me around giving up of children, oftentimes grandparents want to take these children, but they would need to receive notice. So can you speak to why they're not included explicitly? I understand the court has some discretion that's written in, but can you just help illuminate why we don't explicitly make sure that grandparents are notified?
I think it's captured, and there's also a provision that if the court has found from the evidence, that could be even something as little as the affidavit of the mother of the child, that there's another interested party that has lived with the child, contributed to the child's support, or themselves made attempts to legitimize the child, or has provided medical care to the child. So if there are other caregivers of the child and the court discovers these are other interested parties, then they should also be provided notice. And I'm only speculating to a degree, but I think that would naturally capture grandparents. What you're talking, I believe, is in so many circumstances the children are being raised by the grandparent, or many times the grandparent is contributing to their care. So we're trying to capture those people that have been actively involved in the child's life, for sure.
Yeah, I follow that. I think I'm thinking specifically about, it's often paternal grandparents who do not know that child existed, who want to get an opportunity. So they will not have established the things that you just named, right? They may not have provided any care for the child, may not have provided, may not have had any relationship with them at all. But when they learn that they have this grandchild for whom rights are given up, they would want to have an opportunity, because they are biologically related, to have an opportunity to decide whether or not they want to have custody of that child. And so my concern is, by not explicitly including both grandparents, sets of grandparents, in the notice, that this often happens with paternal grandparents, right? That they would have no notice and therefore no recourse or no opportunity to potentially bring that child into their home.
That is a policy question. You know, this does not require service on that paternal grandparent, and nor does current law. But you could, of course.
I think if line 20 that's struck, is that not the current law that would require notice to the grandparents?
It says they shall,
It says shall not. I see.
Yeah, going back
I
up
see.
to line 18,
Yeah.
it should
Yeah.
not be required to be given to.
I apologize. Thank you.
okay, what, Mike 1?
Just to clarify that issue a little, bit, under current law, the grandparents will be notified if only in certain situations. If there are any adult siblings to the child, they're notified. If there are not, then the grandparents are notified. And if there are no grandparents, then the other, some other adult relative, if available, is notified. But under the bill, there is a catch-all provision that provides essentially that any persons who appear to the court to be proper and necessary parties to the proceeding. So that's
What line are you on? What line number?
Believe that is, 32 and 33. Yes. Thank you.
Okay, Senator Burns?
Thank you. Thank you, Madam Chairman. Thank you, Chairman Cowsett, for bringing this bill, and certainly we were very supportive. Just a question of ignorance on my part. In line 30 and 31, we summons the mother, the legal father, or biological father. Is there a possibility that you would have both? Would you ever serve the legal and the biological?
You stumped me on that one, I don't know.
So
I'm
my question
trying to
is,
think through how that could happen.
how would that, I don't know. Would you ever need to, or would you ever desire to, if you knew?
I presume that this applies if there is no legal father, but you knew who the biological father was. But
Does anybody from the department want to comment on that?
I assume that in many cases it would be the same person. Is that correct, legal and biological?
I'm going to call a friend, Attorney Regina.
Oh, I got you. Thank you. Thank you. Help me.
If she's married, then the legal father is.
So, Mr. Chairman, theoretically, the parties in the dependency proceeding could be married to one another.
Yes.
And that could be the legal father.
Yes.
But someone else could be the biological father
Correct.
of the child. So theoretically, it's possible.
Would you summons both?
You would,
You would.
if
So
you knew of both.
I'm a little concerned about the word "or." The word "or" there is my only question. If we were to summon both,
Which line are you on?
I'm on line 30. Yeah. It should be and/or. I don't know. Look at it. That's all I ask.
I'll defer to Ledge Counsel on that question as to the correct wording of the sentence in that scenario.
Thank you.
But it is at least theoretically possible there could be two different fathers.
Two
a
different
legal and a
individuals,
biological.
one legal, one biological. Thank you.
Ledge Counsel Holly Carter. The way that the code is written, I'm sure that it is in some instances in the code where we have and/or, but stylistically, we get away from that and the and or slash, and we choose one. So stylistically, as we write the code, that's not something that we would do unless that is, of course, the insistence of
Does
the
that
author.
change the meaning? In other words, if I know the legal father, do I then summon them and ignore the biological? Or if I know the biological, do I ignore the legal?
I look at it as this is a person that is a party, a concerned party to the proceeding,
To the child.
then they would be required to get notice, no matter who they are.
Thank you. I appreciate it.
You know, just to go back to one of the reasons we felt like this code was necessary was to align the notice provisions, the service provisions, to be the same as they are in termination of parental rights procedures. And that's what we're putting that now in these dependency adjudications to make it be consistent in both parts of our code. You know, the permanent guardianships that we're dealing with. So this inconsistency didn't make sense and didn't serve any purpose. And this way, whatever the type of proceeding is, whether it's a termination of parental rights or the permanent guardianship, you would get the same type of notice. So we're making them identical, essentially.
Senator Press.
So I think in this case, this word is actually going to matter. I'm certainly no attorney, but if we're going to have to choose one, I think you need to choose and, because then you capture both. And then if it's not needed, meaning one of them has terminated their rights, well, then you're covered in line 37. So then the or would kick in. But I think with the or there, I mean, this word really will matter in this case. It could matter in this case. And I think if you're going to have to choose one, I think you have to choose and then should it not matter, or should one of those have surrendered their rights, terminated their rights, then they would be out by default. That's my suggestion. Because I think that was a great catch by Chairman Burns, and I think it really could matter in some cases.
Madam Chair?
Yeah.
Is it possible that we just remove the word or and put a comma and say legal father, comma, biological father? If you could not identify either of those, you couldn't summons them. And if they'd surrendered their rights, you wouldn't summons them. So perhaps just remove the word or.
Okay, we'll get to that when we've gotten the rest of the questions answered, okay? Senator Jackson?
Yes. Thank you, Madam Chairman. Chairwoman, I just, in the event that you have a lesbian couple and who are married, where would the notification for the non-birthing parent, mother, be in this situation?
Thinking it's that catch-all provision, any other person interested that appears to the court to have an interest in it. I think that'd be a pretty clear example of such a case.
And is there a reason why we choose to explicitly name then the legal father but don't reference any legal mother in this code?
Well, we start with the mother.
No, we start with the mother, which I think we presume is biological mother. I'm not sure what mother means here. I guess I'm asking the question. I mean, if it's possible to have a legal father or a biological father, we now live in a world where it's possible to have a legal mother. We've always lived in that world because you could have an adopted mother who's your legal mother, right? So I just want to make sure that we are creating a code that understands the makeup of all Georgia families now, and that includes the possibility of a biological mother and a legal mother. And so if we're going to name explicitly the legal father, I don't understand why we would not include and differentiate a legal mother and a biological mother.
Senator, I believe it's because if you'll look at those definitions that the chair placed in your folder, those two terms are defined. Biological father and legal father are defined in the code. What you're speaking of is not. You would be using undefined terms.
So the law, may I ask another question?
Sure.
So currently the law then does not entertain this current setup where you could have a legal mother who is not the biological mother. We do not currently define that or acknowledge that in our code right now. Is that what you're telling me?
I'll defer to Ledge Counsel on that as well in terms of where it might be. But I think you'll look at Title 19, you'll look at Title 15, and you won't find what you're describing.
I'm sorry.
There's legal mother, definition 44.
Yeah.
What page are you on? Is that the
Seven
definition?
of
Seven of your
26.
supplement.
Does that answer your question?
Well, we don't include legal mother in this bill, so she's not explicitly named, but also the definition as defined here would not necessarily include the scenario that I've created. But I am putting on the table that we need to think about how we create a code that is inclusive of the variety of ways in which families are made in Georgia, and some of those include biological mothers and legal mothers together. And so I don't know how we fix it. I leave that to great attorneys, but I want to name that is missing here.
So,
Senator Hatchett.
I think the issue is because a legal mother can only come about for one of two ways. Either you gave birth to the child or you adopted the child. Those are the only two ways you can be a legal mother. To be a legal father, biologically there are ways you can be a legal father. You could be the child's biological father, naturally be married. You could be married to someone who, had a child with somebody else, and then you're the legal father. But that scenario is not a possibility with the mother. So right now I think legal mother, there's only two ways that you can become a legal mother, but there's more than, you see 4 ways to become a legal father.
So to make sure I'm following here, to be clear, Chairman Hatchett, what you're describing is if you are a lesbian couple, if you are married, the only way for the non-birthing mother to be the legal parent would be through adoption, whereas if you're a heterosexual couple, by virtue of marriage, that father does not have to adopt. It's by virtue of marriage that they become a legal parent. So are you telling me, though, that with a same-sex couple, there's a distinction?
That's how it's written right now. Maybe, that's a good point. Maybe we need to change the definition there in another bill. But the definition of it right now is just those 2 ways, which is why I think we may need to explore something further.
Thank you, Mr. Chairman.
I'd be delighted if the two of you could work on that. Any other comment from the department?
no.
Okay. Okay, so I think we did discuss an amendment, but to do that, we need to get a motion. What's the will of the committee?
Madam Chairman, I'll make some motion to remove the or and replace it with a comma.
I think we have to
Is that
do
what we're
pass
saying?
first.
Okay. Well, I'll make the motion to pass.
Okay. Is there a second? Okay, and you wanted to offer an amendment to?
Amendment to replace the word or with a comma. Is that acceptable?
Yeah, is that?
Council? Is that acceptable? Yes.
I got a motion to amend the amendment. Or a second amendment. I have a second amendment.
Okay, well, let's clear up this amendment first. Don't we have to vote on this amendment first? Yeah. Okay, so Senator Burns,
I'm gonna add legal
you made
in front of
the
me.
amendment.
I made the
And
motion.
you second that? Okay, all in favor of the amendment, raise your hand. Okay, that passes. Now, Senator Brass, you had a second amendment?
Yeah, so according to these definitions we got, there is no definition for mother, but there is a definition for legal mother. So in front of, on lines 30, in between the word the and mother, I would like to add the word legal.
Okay, so who seconded? Okay, Estevez. Any discussion about that? Okay, so all in favor of the Second Amendment, is everybody clear on what it is? Raise your hand. Okay. Now we're voting on the bill. Any further discussion on the bill? We've got a motion to pass and a second. All in favor, raise your hand. I'm not voting. Okay, that passes. Thank you. As amended. Okay, I'm going to ask Vice Chairman Hatchett to take the wheel here for a minute, and I'm going to come down there with Senator
Okay.
Cowser.
Which bill is this going to be? Which is... All right.
Okay. So I'm presenting Senate Bill 135, which has to do with genetic testing. And as you all know, the only law school I've been to is the Judiciary Committee. And so you're going to have to bear with me if there are legal questions. I may have to phone a friend. This bill is, again, has to do with fatherhood, and it modernizes our genetic testing references, and it also allows self-authentication for genetic testing to self-authenticate so that it could then be used in legitimation actions. Because, as you guys probably already know, in Georgia, the biological father is not necessarily the legal father, even if the father's been paying child support. And so this would allow fathers who are seeking to go through that legitimation process to be able to use those genetic testing results. So if you look at Section 1, that's the part that revises. It's a name change about the group that does the genetic testing. And then Section 2 addresses self-authentication of the results and admissibility into evidence. And it further defines the conditions that have to be met to make the results of the genetic testing legitimate.
Madam Chair, where it's in this page, where I am.
I have page 1 and 3. I don't have section 2.
I need page 2.
I thought there was something wrong with my reading for a
That's the same
flipping
here.
back and forth. Man, that must be my reading.
Okay, then what we can do is, while we're waiting for the third page to be copied, I'll come back up there and we can go on and ask Senator Cowser to present the next bill. Thank you. Sorry about that.
That's fine.
Okay, sorry about that. We'll come back to that and go ahead and ask Senator Cowser to talk to us about Senate Bill 133.
All right. Thank you, Madam Chair. Senate Bill 133 is a method of establishing a uniform process that would be the same when DFACS is assuming custody of children as a result of two different types of orders. One is a delinquency disposition hearing, and the other is a child in need of services hearing. These are hearings conducted by a juvenile judge, and they often will give a order just from the bench, and they call that we reference that as custody from the bench, where they may be changing custody of these children into DFACS care, or their custody, just with an order from the bench after their either delinquency hearing or after a child in need of services hearing. And what this ensures is that DFACS and other parties to that delinquency, or we call them CHINS cases, the child in need of services cases, to try to keep the child from unnecessarily coming into foster care system. So to let DFACS get involved and make sure that there's not an alternative before we just directly from the bench put these children in the custody of DFACS and ultimately in the foster care system. So this sets up a uniform framework to allow for early intervention of the children, protect everybody's due process rights, their constitutional liberty, interest, and allow for sharing of information between the various state agencies to secure the most appropriate placement for a child. And so what you will see if you track the language in the bill is the requirements that before a juvenile judge is doing this disposition in either a CHINS type of process, which is under Section 1, or the delinquency process under Section 2, that they have to, for example, on line 14, inquire of all the parties as to what services have been provided to the child. And what services are available to the child, and that all the efforts have been exhausted of other places of custody other than in the custody of DFACS. And we want to have a Child Protective Services report made to the statewide Child Protective Services Intake Communication Center so that this can be shared amongst the different state agencies. They'll understand. Requires notification to DFACS, give DFACS sufficient time to make efforts to avoid removal of the child into DFACS custody, and give them a meaningful opportunity to request a continuance so they can continue their good faith efforts to find a home for the child other than the foster care system. So we're trying to require juvenile court judges before they do these orders of custody from the bench to comply with all these requirements, to make certain that we first explore and exhaust all other potential placements for that child that's in the best interest of the child before they go into DFACS custody. And that's the easiest way I can just sort of summarize this. So we're repeating a lot of the language in both delinquency proceedings and the CHINS proceedings, so they'll be consistently upheld. That's why we say it's to uniformly treat the placement of children and to exhaust all other opportunities before putting them in DFACS care.
So before I go to questions, I want to let the committee know that there have been some conversations going on, some feedback about the bill, and some talks with the juvenile justice judges, and we're not going to vote on this bill today. We're trying to get everybody's questions answered, and this bill will be back next week. So I would like to go ahead and get your all's questions on the table.
So, basically, currently, these juvenile courts across the states all just independently decide, how their cases are going to proceed following the disposition of delinquency or a CHINS case. They decided on their own. This gives them specific uniform guidelines that will be used statewide and reporting requirements.
Okay, Senator Jackson.
Yes, thank you, Madam Chairwoman. Mr. Chair, where are these children? Where are these children being held in the meantime while we're waiting to make sure that all efforts have been exhausted?
I imagine in the delinquency proceedings they're being held in youth detention centers. So these are delinquency proceedings on the child. There may be other areas, but I think that would be predominantly what you're seeing there.
So what we're choosing between is keeping a child in jail versus moving them into a foster care system where we're not sure we have a bed?
By the court's order without first exploring to make sure there isn't a reasonable alternative. That's what we're trying to do, is to keep them from just going straight from YDC into DFACS care when they're released from there. or into a foster care home, let's first exhaust all other reasonable opportunities for a more suitable home for the child.
Sure. And is there a time frame associated with that, since these children are sitting in jail while we're waiting for that? And how do we define exhausted all efforts? What does that mean?
Well, I don't know that we've defined that, but yet there are some time processes certainly in the juvenile proceedings.
Senator Mallon.
Thank you, Madam Chair. Senator, thank you so much. To speak to this bill, this is an issue we have in Chatham County, and oftentimes the court has records that the Department of Family and Children's Services does not have. They do not have access to some of the information the court may have, and so getting that information for the agency has been extremely difficult. Even when it comes to the notification of pulling the child's birth certificate to find additional relatives, the agency doesn't have access to the records. The court may have all of this information, but is not at liberty to share it with DFACS. And they put the child in foster care with DFACS, and DFACS still has no access to the records. They don't know any school records. They don't know any of this information. And in conversation with my local DFACS folks, this is to allow them to have at least 24 hours to get all of this information to make sure before the child gets into DFACS custody, because that child may have to leave Chatham County and go somewhere else in another county. But if they had access to the records and information, they may be able to find alternative placement with another relative or family member if they had access to the information to do so. Is that true?
I believe that is true, and this, of course, is giving DFACS notice in any of these proceedings to give them reasonable time. As you know, I don't guess we've specified exactly how long to look for those other type of more suitable dispositions or accommodations for the child.
Senator Merritt.
Thank you, Madam Chairwoman. If a child is in immediate danger, my question is can we speed up this process to remove them from immediate danger, and then can we speed up the research if they're in immediate danger, and then where are we placing them, as Senator Jackson said, if these children are in crises and they are in immediate danger?
Okay, so in the definition of a dependent child, that's a child that's been abused or neglected or is in need of protection of the court. So I think that's kind of addressing what you're saying, immediate danger, or else a child that has no parent, guardian, or legal custodian.
Okay.
The code requires already that if a dependent child, as we just described, one of these that is being abused or neglected, is removed from their home, that a preliminary protective hearing shall be held promptly and not later than 72 hours after the child is placed. So the purpose there is we want to determine the probable cause, whether or not the child is dependent, been abused or neglected, et cetera, and whether protective custody is necessary to keep them from continuing, being subjected to the abuse or the neglect. And then, of course, you're looking to give the parents their constitutional rights before you take their child away and put them in protective custody somewhere, or whether with DFACS or a foster home, or if we can find an alternative, more suitable place for them to be taken care of.
Senator Payne, you were next.
Thank you, Madam Chairman. And this is I love what this bill is trying to do, because I was there when we used to have unruly cases, unruly children, and with unruly children, we usually do an informal probationary period without going to court for 90 days, and it's an agreement, an informal adjustment agreement, so the child, which allowed us the ability to put things in place. But when CHINS came along, these kids really started falling through the cracks because nobody knew what their role was. At DJJ, DFACS, we didn't know of these, we can't detain them anymore. We really don't, they can't treat them as punitive for the action, even though it's a charge against the child. And so this is, I think, a great step in the right direction, trying to put it so that we're putting services in place for these kids because, you know, I think for a time period there, they were just falling through the cracks and nobody really knew what to do when we changed them from an unruly against the child to chins, where that was more of a defects issue. So I welcome this bill. The one question I did have is, does this allow for punitive action if the court deems necessary against the parent themselves?
May have to call a friend on that one. This bill does not provide for that. This is to make sure that juvenile court orders are all uniformly applied, taking these procedures into account. So I don't think that's going to be in this code section, but there certainly may be.
Because, I mean, I can tell you from many years' experience, these kids, a lot of these are the ones that are, the kids are not the problem, the kids are the result of the problem. And, you know, just because an adult can file a charge doesn't mean it's the kids that's wrong. And I mean, just, I can tell you countless stories where a lot of times it's the parent trying to get rid of their kid. Yeah. And so I think that we need to put more teeth in our thinking toward those who are in custody of these kids, so that these kids are not just continuously punted, because that's what as I said many times, y'all have all probably heard me say it, I was the guy standing at the edge of the cliff trying to catch all those kids that were being punted for years throughout the system. And so I think at some point we need to look at adding teeth back to this kind of legislation that holds parents accountable for being good parents.
Thank you. Unfortunately, Senator Kauser's out of time because he's got to chair another committee at 2 o'clock.
2 minutes.
Yeah. So we're going to have to answer more questions later when we bring the bill back or offline, if that's okay with everybody.
And if I'm lucky, the real expert on this one, Senator Strickland, will be here to answer.
Yes, he will be here.
Probably better than I can.
Yeah, and with that, I'm going to step back down there and we'll try to finish dealing with Jeanette. Okay, Chairman Hatcher, are we ready?
We are ready.
Okay,
You may
so
go
now
ahead.
you should have all your pages of Senate Bill 135 about genetic testing. Yeah, you should have all the pages you need. So Section 1, as I was saying, is basically updating the using guidance from the Uniform Parentage Act of 2017, updating the bodies that do the testing. And then Section 2 talks about making the paternity genetic testing self-authenticating so that someone who's trying to go through the legitimation process can use that as evidence, can introduce that as evidence themselves. And that's pretty much what the bill does. It also defines what has to happen with the genetic testing. It has to be signed under penalty of perjury, and it must have the name and photograph of each individual whose specimen was taken, who collected it, the place and date. So chain of custody, basically. So just to summarize, in Georgia, the biological father's not the legal father automatically, and so fathers going through the legitimation process, this is a way to speed up the process and make it easier for them to get through. So with that, I will try to answer questions, or I will ask for help.
Looks like you have one question.
Thank you, Mr. Chairman. Madam Chairman, how many of these laboratories are accredited in this state by this association?
I'm not sure. You know?
Do we know?
No, but I'll try to find out for you. More and more? Yeah.
Is there, yeah, that's my main, is it 1, 2, 10, 20?
I think there are a number, but I don't know. You want to come up here? Yeah.
I'm always a little leery of these types.
Senator, this is the standard accrediting body. This is just their new name.
No, I get that.
Yeah, there are lots of them. Yes,
I mean, if I'd been here when it passed, I would ask the same question originally, when it originally passed. But I'm always leery of these accrediting bodies because there's typically, it limits it down to a narrow scope of companies or laboratories in this case that would be accredited, and that's my fear. And if we're, when we're talking about, these types of cases, we've got backlogs all along the system, and if we're gonna, if we only got one or two companies doing this in this state, and I'm not saying we do, I'm just asking the question.
So, Senator, to that point, this bill actually gives more flexibility by adding at lines 20 and 21 any other accrediting body designated by the Secretary of the United States Department of Health and Human Services, which is, of course, where the rules and regulations regarding the child support services are promulgated. So this actually adds more flexibility to the code.
This opens it up beyond the blood banks.
Okay. Well, if we could maybe get a number before we get to the floor, that'd be good for me.
Okay.
Thank you.
Will do.
You have no more questions? Has anybody signed up to speak?
I'm sorry.
Oh. Senator Merritt.
Thank you, Mr. Chairman. Who is these? I realize these are court-ordered tests. Who's paying for the tests?
I think it's usually the person who's being tested. Am I correct? Depends is the
Okay.
answer.
So then my question is, for parents who can't afford the testing, who is helping them pay for that?
My understanding of the cost of the test is it's less than $100, but I'm not sure that's defined in the law.
Yeah, less than 100 for, I don't know, depends on people's circumstances
it's
these
not-
days. That still might be too much.
And,
That's
and
not
there are
contemplated in
things
the
called
bill.
pauper affidavits that you can sign at the courthouse that can help with people that can't afford that. And
That's not,
yeah,
they
those
can
are
get
available.
some help.
Yeah,
Okay.
they can. Yeah. You have no more questions. What is the will of the committee? Got a motion to pass. Got a second? All those in favor, raise your hand.
You've got an amendment. Hold
Oh,
on.
Oh,
hang on one second. Are there any amendments?
Now,
You're good to go.
I'd like to offer an amendment on, I'm going to amend line 56. I'd like to delete the words "a report" and replacing the words deleted with "the results."
All right, so on line
And
56.
what I'm trying to do here is align terminology in new subsection B with that in existing subsection A to avoid any confusion.
That's a good point. So you want to take a report and
All right.
replace it with the results.
So we're amending line 56 by deleting, quote, "a report," end quote, and replacing the words deleted with, quote, "the results," end quote.
All right, so that is a motion to amend. Do we have a second? Second. We have a second. All those in favor, raise your hand. Those opposed? Okay, so now we are in the posture. We had a motion to pass. We've amended it as a substitute. What is the pleasure of the committee?
We already got a motion to pass.
They got that.
Let's
So
take a vote.
the vote. All right, we're voting on passage of the bill as amended. All those in favor, raise your hand. Those opposed, same sign. It's unanimous. Thank you.
Sorry, Kay, I forgot. Huh? No, man, I was up all night. I was up all night coming up with that. You know, I read every bill and every.
Thank you all for being patient with all of our changes of sponsors today, and we're going to address Senate Bill 133 next week again. And did you have something to add?
I'm sorry, Madam Chairman, I'm Eric John, the Director
Come on
of
up.
Council of Juvenile Court Judges. I just wanted to let the committee know that we've been working with the department, with Ms. Quick and Candace Brose on the bill, and questions are coming up. Our judges are ready and willing to answer any question. And we have two good judges. Judge Hurd from y'all heard earlier last week about Hoteling, who's been through everything in the dependency side, helping Judge Michael Key from Troup County, who's our dependency expert. So we are helping everyone involved in this process. I just wanted the committee to know that, and willing to answer any questions as they come up.
Great, thank you. So we'll be dealing with likely a substitute bill when we come back next week on 133. So if you have any other suggestions or thoughts about that, please let me know and I'll get them to the department. We are adjourned. Thank you.